We'll now move on to the keynote address. Justice Ferdino Rebello will be speaking on articles that protect human dignity. Honorable Justice Ferdino Inacio Rebello, former Chief Justice of Allahabad High Court and former judge of the Bombay High Court. He completed his education, LLB from Government Law College, Mumbai, and enrolled as an advocate on 30th July 1973. He practiced at Panaji and the Panaji bench of the Bombay High Court, including service, constitutional, and local self-government matters. He served as President Goa High Court Bar Association and was designated as senior advocate in December 1995. We now invite Honorable Justice Rebello to give us the keynote address.
Good evening to everybody and happy Republic Day. I'm sharing my thoughts, perhaps in a slightly different perspective of what we as minorities in India are facing today. As pointed out, I enrolled as an advocate sometime in 1973, precisely 30th July 1973, and took an oath on 15th April 1996 to uphold the Constitution and the rule of law. Though I have demitted office, I have not demitted that oath and continue to fight for causes, the marginalized, the rights of the SCs, STs, and other disadvantaged groups, which I was advocating in my young days as a lawyer and now continue to do so post demitting office. Now, I will like the preamble has been pointed out by both the previous speakers, but I would like to focus on a few words of that preamble, because I'm going to argue in the context of those words. And that is liberty of thought, expression, positive, belief, faith, and worship. Now, these are words found in the preamble: belief, faith, and worship. And has been said in the judgment in Goloknath, these are the key aspects of the Constitution of India. So therefore, when I'm articulating the right of a citizen to faith, belief, and worship, what are the rights of an Indian citizen, of minorities in India? Because basically, these are cradled under the chapter articles 25 to 30 as rights of minorities, which are both religious minorities and linguistic minorities. Now, today, we are facing all minorities, whether it be Christians, Muslims, or basically these two minorities are facing issues in what are called freedom of religious bills, which have practically strangulated the right to profess, practice, and propagate. The punishments are harsh. One act has gone to the extent of saying that you can demolish the house of a person if he is found propagating a faith. Punishments are very harsh. Matters are pending in the Supreme Court. As I understand, matter will come up on 28th of January. Matter will not go on because so many things have to be done, possibly. But there is an unprecedented attack on the rights of minorities in some of the states, mostly in the northern states. And therefore, I am spending some time to articulate on these rights. Now, the first right that I'm articulating is Article 25 of the Constitution of India. Now, this article says, subject to public health, moral, public order, etc., every citizen has the right of freedom of conscience and the right to freely profess, practice, and propagate religion. So, though, as pointed out, the right to propagate was recognized because some of the members of the Constituent Assembly did point out that the right to propagate is an essential part of the Christian faith. And therefore, the right not only to profess and practice, but to propagate became a part of Article 29 or 25. Now, this sometime in the 60s, mid 60s, two state governments, one in Orissa and one in Madhya Pradesh, introduced the first what we described as freedom of religious bills. The Orissa High Court struck down the act on the ground that it violates the fundamental right to propagate. The Madhya Pradesh High Court upheld the law on the ground that if there is disturbance of public order, such a law is found to be within the constitutional framework. The matter came up before the Supreme Court in what we know as the Stanislaus judgment, Reverend Stanislaus. It was a constitutional bench judgment, and by a majority, and they were unanimous that a law could be upheld under public order. Now, this judgment immediately came up for severe criticism from eminent jurists, and one of them was Mr. Sirve. Now, I'll quote to you what he has said in his book, The Constitution of India. A small paragraph out. That brings us to the basic misconception in the judgment of Ray C.J. as to the nature of freedom of religion. Dropping freedom of religion, he turned to the phrase freedom of conscience to suggest that the freedom of religion included the right to convert even by persuasion. It would interfere with the freedom of conscience of the person who was converted. The meaning of the phrase freedom of conscience given above puts an end to that argument. First, Article 25(1) confers freedom of religion, a freedom not limited to the religion to which a person is born. Freedom of conscience harmonizes with this, for its presence in Article 25(1) shows that our Constitution adopted a system which allows free choice of religion. So therefore, Justice Sirve has articulated and contended that this judgment requires to be recalled. And based on this judgment now, we have a plethora of laws coming from a number of states in the country, which are practically, I would use the expression, abridging the right of minorities to practice, profess, and propagate. Figures available for last year itself, as put out by ADF, these are known figures, that over 400 Christians there have been cases filed against them. There are incidents coming from various states where there is bodily harm on nuns, there is bodily harm on pastors and priests and laymen. And therefore, when we celebrate this Republic Day today, I ask myself, what are we really celebrating a Republic Day? Does the Republic Day mean to us what the founding fathers had given to us? An instrument to protect the right of every citizen of this country, an instrument to make every citizen feel that he is a part of this great nation and that he can, in exercise of his conscience, choose what religion he seeks to profess. And sometimes I wonder to myself when somebody says that somebody has been forcibly converted. Is conversion something like putting a man in steel chains from which he can't free himself? If he says that he has been wrongly converted, he can always walk out of that. But these are aspects possibly where the Supreme Court would consider the days ahead. But importantly, there is some new development in our constitutional law which has taken place, and that is the Puttaswamy judgment. In Puttaswamy judgment, the Supreme Court has now upheld the right, that the right to practice a profession or propagate or profess a religion is your individual private right. In other words, a privacy right. And this privacy right cannot be infringed upon or infringed upon unless you show reasonableness in any law that you put. So I don't articulate more on this because the matter is now in the Supreme Court. And hopefully someday, as the law stands, as we understand the law, Stanley's laws will be recalled. The harsh and disproportionate punishments that are imposed under these laws, the matter is under consideration for interim reliefs. So hopefully again, possibly, some relief may be granted. We can't speak. That is ultimately the discretion and the jurisdiction to be exercised by the Supreme Court. So today, practically, though Article 25 is in our Constitution, in so far as what it means to us is totally different. It is practically a negation of what the founding fathers wanted the citizens, the minorities to have in this country. Now, having said so, I come to the next part. Under Article 26, every religious denomination has the right to establish and maintain institutions for religious and charitable purposes and manage its own affairs in matters of religion, etc. Now, just look around you. In exercise of this right, Christian institutions have established charitable institutions, and these charitable institutions have been and are providing various socio-economic activities, healthcare, care of orphans, care of women who have been facing distress, helping the Adivasis to rise, to get their rights, an immense contribution by a small community, contributions which are recognized time and time again. So therefore, the contribution of the minorities, including, as I say, Christians, in exercise of this right of Article 26 has been immense. Then we have two other articles. Article 30. Now, Article 30 of the Constitution confers rights on minorities to establish and administer educational institutions. Even before independence and post-independence, these institutions are there in every nook and corner of the country, providing quality education, enriching minds, and providing access to justice, to education, which for thousands of years had been denied to large sections of our community. I will tell you what one of my colleagues on the bench one day mentioned. He said, if it was not for these Christian institutions, we would have been where we were, in the dark, uneducated. Thanks to them, by education, we are now educated and we can stand on our own feet. This was an acknowledgement by a colleague of mine, a judge, who spoke about the impact that education brought in the length and breadth of this country. So today, if we are proud of, as a community, Article 30 gave us that right, and that right has been used by institutions, by minorities, especially Christians, not to convert. They have been used to give young children an access which otherwise they would not have. They are brought together in the same classroom, people of different castes, people of different religion, who study together as brothers and sisters, and as pointed out, fraternity is administered and seen in our classrooms, in our institutions. That is what we have contributed to this nation. Fraternity, which is the corners to which the preamble said, and in these classrooms of ours, we teach this, we bring this together. You will not find that somebody is denied admission in our institution because of caste, race, creed. It is irrespective of that. And so, this has been a major contribution of the community or the minorities in helping India reach where it is today. If it was not for these young minds who were given this education in the primary schools, in the secondary schools, in the colleges, in the professional institutions, which helped shape them, perhaps we would not have reached the stage where we are today. And today, when you find somebody, he will always say, I've come from this institution. And it's with a matter of pride that they say the achievements are because we got this freedom. If somebody did not have the means, he was given a chance without paying fees. And today, in a state like Uttar Pradesh, giving free education to a child, to a person, is considered to be attempting to convert him. Look at the stage where we have fallen. Look at the stage where the Constitution gave us the right, and this right was used to educate young minds, and what we are facing today in certain states. But be that as it may, the community is never cowed down. We are a strong, resilient community. As Christians, Christianity did not spread by force. It was a matter of belief by persons who believed in certain ideas that our faith taught us, that Christ taught us, and others have articulated these thoughts. So we move forward irrespective of what we face, hoping that someday our voice will be heard, that an independent judiciary will realize the contribution, and that is harsh laws which have been enacted will not stand in our way of contribution to building this nation. Many a times, many of our priests and prelates think that you cannot impart religious education in the institutions. Now, perhaps Article 28 has not been brought to the attention. Under Article 28.3, it is possible to impart education, religious instruction, if the person concerned of his parent so agrees. But today there is a fear everywhere, and expressed in every meeting or gathering that I go, that if you start teaching religion even to our own students, not to others, you teach to your own students, there are attacks on the institutions. Today I just read in the morning that there were, and it is happening in a state like Madhya Pradesh, where forcibly people have been told in a Christian institution that students must have access to the majority faith. Now, a person in our institution will teach moral sciences to all students. So somebody can always go have somewhere out. But how do you force in minority institutions, impose upon them that because there's a section of students, maybe a large section, that they should be entitled to practices of their faith? This negates the right of a minority institution to run the institution. Now, having said so, let me go to the next part, which is Articles 14, 15, and 16 of the Constitution. Now, what are these articles? Article 14 is the one of the cores of a constitution that a state shall not discriminate against any citizen. In other words, every citizen has a right to be treated equally. Then there are two other articles. Articles 15, which say that states shall not discriminate based upon caste, etc., etc. But the same article also provides for exceptions. Now, what are these exceptions? They say it is open to the state to make reservation for women and children. They say it is open to the state to make reservations for socially and economic and educationally backward class of citizens, for the SCs and the STs, and this relates to mostly professional institutions, admission to professional institutions, school, etc. And then we have Article 16. Again, we say there shall be no discrimination, but then provides for reservation in employment to socially and educationally backward class of citizens. Now, this was the constitutional philosophy. Now, why did the Constitution so provide? And how is it important in the context of Christians? You may ask. These are articles which span everywhere to all sections of the citizens, to the OBCs, SCs, STs. So why is it important insofar as Christians are concerned? Now, we have a large section of the Christian community which has come from the SC community. Now it is pointed out that Article 17 has abolished untouchability. Now, in the Hindu Varna system, such people were considered to be untouchables. They did not form a part of the four Varnas. That is the Brahmin, the Kshatriya, the Vaishya, and the Shudra. They were even outside the Shudras. But in the Constitution, Article 341 has conferred power on the president to notify what are called scheduled castes. Now, the scheduled castes may be many of them may be these untouchables, but they are also groups. But once they are notified as SCs, they are SCs for the purpose of the Constitution. They lose their color, perhaps, which was there earlier. And the president, while issuing the notifications, insofar as Christians and Muslims are concerned, said they would not be entitled to reservations as provided in Articles 15 and 16. So there is why I'm trying to point out these articles. Now, the matter came up before the Supreme Court. Some petitions are still pending in what is known as the Susai judgment. There, the Supreme Court really did not answer whether this law would be offending Articles 14, etc., but said that you must compare yourself, that if once you join that religion, or you start not join, profess, say, a Christian faith, that you are suffering the same disadvantages which you were suffering before conversion. And they said there is no material before us to arrive at a conclusion that you are suffering the same disabilities. So the point was not rejected that you cannot get benefits, but our point, the Supreme Court proceeded on the basis that material has not been placed. Now, subsequent to that judgment, the Raghunath Mishra Commission was set up. They have pointed out the disabilities that have been faced by Christian communities, other minorities. The Sachar Committee was in respect of Muslims, but they also have pointed out disabilities suffered by other communities. But instead of following the recommendations of the Raghunath Mishra Committee, the Government has now appointed a new commission, the Justice Balkrishna Commission, which is now looking into the issue as to whether after conversion, converts to Christianity suffer the same disabilities which they were facing under the before their conversion. But the question which I am asking, and perhaps all of us must have asking, was a Buddhist, for example, they don't believe in castes. There's no casteism. They don't believe in caste, just like Christianity does not believe in caste. But yet, they are given the benefit of reservation by putting them in the larger definition of Hindu. Sikhs is the same position. They don't believe in caste, but yet they have been given the benefits of reservation. Nobody has called upon them to contend or put on material on record to say whether after conversion they suffer the same disabilities before conversion. Now, how can then some minorities be called upon to prove that they suffer disabilities after conversion and some communities not? Because whether once you are notified as an SC, as the Supreme Court now itself says, you continue to be an SC. But for the moment, Christian converts to those convert to Christian community or the minorities, Muslims, are not entitled to take the benefit of reservations under Articles 15 and 16 as SCs. In some states, they have been notified as OBCs, which is a larger group, and they can be entitled to reservations as OBCs. Now, many a time, people have not understood what this OBC is. It is always understood to mean other backward castes. That is not so. OBC is other backward classes. And the Supreme Court has said that yes, a caste may be socially and educationally backward, and therefore it falls into that class. So therefore it is other backward classes. Then we come to the STs. The presidential notification, unlike SCs, does not speak about any religion. Therefore, STs are entitled to all benefits if they choose by their conscience to profess the Christian religion. But yet again, there's a vociferous voices in states like Gujarat. They are, though in law they are entitled to, I'm given to understand that they have been denied the benefits. In so many other states, also that's what I've been given after speaking to various people. So though they are entitled to rights, yet they have been denied the rights. Now, how do we work? It's a matter for groups working in those states, how best to work out and fight for the rights of these STs who by their conscience have chosen to practice Christianity. So these are why the implications of SCs and STs. Then I come to the next head of Article 21. Now, what is this article? Article 21 speaks about the right to life and liberty, two great components of an individual, the right to life and the right to liberty. Now, the right to life does not mean just living. It means everything that we can imagine. The right to clean air, the right to protect, the right to a clean environment, the right to roads, accessible roads, the right to drinking water. So these are various rights which flow from Article 21 of the right to life. And many a time, and how has this right expanded? See, this is now in many parts of our southern states, the mango trees which were there have started blossoming, and now perhaps the fruits are coming in. So Article 21 has blossomed like that. It has fruited. And it has fruited because the Supreme Court, in its long journey, though at times I said It failed us during the emergency. Post-emergency, it has charted a new course. It has swept aside several cobwebs. It has set aside certain artificial distinctions they had made for themselves earlier, that Articles 14, 19, 21 cannot be read together. Now, post-Manika judgment, the Supreme Court has said that all these articles, 14, 19, 21, can be read together. They are known as now as the Golden Triangle of the Indian Constitution. And in this Golden Triangle came up issues. The first of the issues which came up, where as a young lawyer I remembered, was that a person had no means to pay a debt because he had no means. And the law required that he be put into jail because he could not pay in execution of a decree. And we had Justice Krishna, one of our greatest jurists. I call him the founder of Indian jurisprudence. He went to international conventions, and from that conventions, he said, if a man has no means to pay, how do you jail him? That affects his right to life. And how do you read the international convention into our constitution? They said if India is a party to an international convention, then that convention can be read into Article 21. And if it can be read into Article 21, it can be made enforceable. So in a myriad of cases, Article 21 has now blossomed, giving rights to citizens. For example, in the field of environment, we have developed what is called the concept of sustainable development. And this contains three great principles. The polluter pays principle, somebody who pollutes must pay. The principle of intergenerational equity, and the other principle is that you must prove that when you put up a project, that will not harm the environment, not only today, but in the foreseeable future. So we have developed this concept of sustainable development by reading it to Article 21. And the great development of the law is in what is called the public trust doctrine. The public trust doctrine has been used to protect our natural resources. It is now recognized that forests, hills, rivers, the coasts, the seashores are not of the ownership of the government. The government is the trustee for the people. And as trustee for the people, governments can't interfere with these rights. Sometimes, yes, marginally, to some extent, to a limited extent. When perhaps you have to balance, then you apply the principles of sustainable development. And what I said, the precautionary principle, which I said, I missed the word, the precautionary principle. So therefore, there's a huge expansion of Article 21. And then we have liberty, read with Article 22. Now, this is an area where also rights of citizens have been protected. But unfortunately, our courts have become regressive in some matters. And what we call is bail. Now, the right of a person may commit an offense. You may require some time to investigate it. Yes, bail, but that man can't be kept forever for years together in jail. And unfortunately, today, jail has become the rule, bail an exception. Of course, there are some judges who have now trying to move in, change the course. I only hope that as we move forward into 2026 and onwards, our courts will see better light, better enlightenment, and citizens' right to liberty is protected. I think I am crossing my time, but I should wind up. Though the subject was so vast, and in the process of trying to articulate something, because I thought that we should know what is happening in the country today. I have tried to expand on I've tried to point out to all of you the state of position of the minorities in this country. So I thank the organizers for giving me this opportunity, and Robin for allowing me to perhaps cross the time limits. So thank you,
Yes.
everybody.
Yeah, I can't stop a judge because I'll be in contempt otherwise. So, yes, thank you, Justice Rebello, for a very comprehensive view of several issues. I can clearly see that there are many issues that need to be addressed. You did talk about Stanislaus. You did talk about Article 28.3 about consent. You raised some serious issues about SC, ST, Article 16, the expansion of Article 21, and also you raised some very important issues on environmental justice, saying that the government is supposed to be a trustee. So thank you. In fact, we are going to have questions. There will be a Q&A session at the end of this program with the panelists.